Welcome to the deep dive. Today, we're tackling something a bit different, maybe even overlooked. We're going deep on the Third Amendment. Seriously, be honest with yourself right now. Could you actually quote it? You probably know the first, maybe the second, the fifth.
Yeah.
But the third, it's kind of the forgotten one in the Bill of Rights.
That's right. It's often seen as this historical relic. But the text itself is incredibly direct. It just says, "No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law."
Simple enough. Okay, let's unpack that. The immediate question is why? Why was this specific protection so important to the founders? They put it right there near the top.
It really boils down to direct experience, specifically colonial trauma. This amendment is a direct reaction to the British Quartering Acts. There were a couple, 1765 and then 1774.
Right, it's the second one being one of the intolerable acts. They call them that for a reason.
Exactly. Imagine the government just telling you, hey, you've got a spare room, maybe even just a barn space, so now you have to house and feed soldiers. No asking, just telling.
It wasn't just inconvenient. It felt like a fundamental violation, right? An invasion of the home.
Precisely. It struck at that core idea, later put nicely by Justice Story, that a man's house shall be his own castle. The power to say no, especially to the military, entering your home that was seen as absolutely crucial for liberty.
And what's kind of amazing is how effective it was just by existing. You mentioned it was adopted in 1791.
Yeah.
And apparently, for almost 2 centuries, right up until 1979, nobody really had to use it in court.
That's the remarkable part. It basically did its job just by being there. That's why you hear legal scholars sometimes call it the runt piglet of the Constitution. It's just there.
Ah, the runt piglet?
Yeah, and the Supreme Court has never actually made it the central point of any decision. It was mostly a history lesson.
Until. It wasn't. Until it unexpectedly slammed into a modern situation.
Yeah, right. And that brings us to the really fascinating part of the story. The one case where this amendment got a serious workout in federal court. Ingram v. Carey, 1982.
Okay, so set the scene. This isn't redcoats and muskets anymore. We're in New York State, 1979.
That's right. There's a statewide strike by New York's correction officers.
What?
The plaintiffs in the case, Marion Ingram and Charles Palmer, were among them. Now, the key detail. They lived in staff housing provided by the state right there on the grounds of the prison, the Mid-Orange Correctional Facility.
Okay, so employee housing, dorm rooms, basically.
Pretty much dormitory-style rooms. So when the strike hits, Governor Hugh Carey calls in the New York National Guard to keep the prison secure.
And the striking officers.
They were essentially locked out, barred from their rooms, and then the state moved the National Guard troops, about 260 at the peak, into those very rooms.
Wow. Okay, I can see where this is going.
The officers sued. They claimed this was exactly what the Third Amendment forbids. Quartering soldiers in their houses without their consent. Suddenly, this dusty old amendment was right in the spotlight.
This must have thrown up some immediate legal problems. First off, are National Guard members really soldiers in the way the founders meant? Weren't they thinking about, a standing federal army?
That was definitely a question the court had to tackle. The text just says soldier. But the court looked at the function and the history. They decided that the National Guard, especially when operating under state command like this, not federalized, is basically the modern version of the state militias the founders knew. And since the amendment was aimed at protecting people from both standing armies and militias being forced on them, the court said, yes, for Third Amendment purposes, these National Guard members count as soldiers.
Okay, hurdle 1 cleared. But wait, the Bill of Rights originally only restricted the federal government, right? How could this apply to actions by the governor of New York?
Excellent point. That brings in this really important constitutional concept called incorporation. It's a bit technical, but basically,
It's how bits of the Bill of Rights get applied to state governments too, using the 14th Amendment.
exactly. Through the 14th Amendment's Due Process Clause, the courts have gradually said that certain rights in the Bill of Rights are so fundamental, so rooted in the tradition and conscience of our people, that states have to respect them too.
And the Third Amendment made the cut. It's considered that fundamental, even though it's barely ever used.
Apparently so. The court in Ingram reasoned that the core idea, protecting your home from military intrusion, is fundamental. If a state could just barge in with troops, that would fundamentally undermine liberty. So yes, it got incorporated. It applies to the states.
So legally, we have soldiers, and we have the amendment applying to the state. But that wasn't the real fight, was it? The core of the Ingram case seems to be about the living situation itself.
Precisely. That's where the real legal innovation happened. The amendment protects the house of the owner. So the million-dollar question was, were these correction officers living in state-provided dorms actually owners of their houses in a constitutional sense?
Because it sounds like their connection to those rooms was pretty thin. You mentioned they paid rent, but how much?
It was minimal, like $36 a month, taken right out of their paychecks.
And the state still had a lot of control, right? Like inspections, rules about guests.
Oh, absolutely. The administration kept a master key, had the right to inspect the rooms, restricted guests, the works. It was definitely tied to their job. If they lost the job, they lost the room.
So the first judge who looked at this, Judge Sweet in the district court, he basically said, no way, right?
He did. He dismissed the Third Amendment claim. He took a very traditional property law view. He said their right to be there was just possession incident to employment.
Meaning it wasn't like owning a house or even having a formal lease?
Exactly. He focused on who held the actual property title, the fee simple ownership. That was the state of New York. So Judge Sweet reasoned the state was the owner, and the state, through the prison authorities, could consent to having the guilds stay there. The officers didn't have the property right needed to object under the Third Amendment.
That seems logical from a strict property law perspective. But it feels like it misses something about the idea of a home.
It does, and that's why the appeal is so important. If that ruling had stood, the Third Amendment would basically only protect people who own property outright or have very formal leases. Renters, people in employee housing, lots of modern living situations wouldn't count.
So the Court of Appeals, the Second Circuit, they saw it differently.
They really did. They reversed Judge Sweet's dismissal. They rejected that narrow, formalistic reading based purely on who held the deed.
How did they justify that?
They looked at the purpose of the amendment protecting privacy and the sanctity of the home. They argued that the term owner in the Constitution couldn't just mean literal title holders. That would be kind of an absurd result in today's world.
So they broadened the definition.
Yes. They said owner has to extend protection beyond just holding the deed. It includes anyone with a lawful right to possess the property and, crucially, a legitimate expectation of privacy in that space.
Legitimate expectation of privacy.
Yeah.
That sounds familiar, like from Fourth Amendment cases about searches.
Exactly. They're connecting it to that broader constitutional idea of privacy. It's not just about property documents. It's about whether the space functions as your home, a place where you expect privacy.
So what facts did they point to for the officers?
Well, the fact they paid rent, even if small, the fact that these rooms were, for many, their only residence. They furnished the rooms themselves, curtains, toilet paper, light bulbs,
They made it their home, essentially.
Right. And interestingly, even some of the facility's own documents use terms like landlord-tenant responsibilities. The appeals court said, looking at all this, you couldn't just say they had no significant interest. They concluded the officers might indeed have a substantial tenancy interest and real privacy rights there.
So they didn't definitively say the Third Amendment was violated, but they said the officers deserved their day in court to prove it.
Precisely. They reversed the dismissal and sent the case back for a trial to determine if the officers' possessory interest and privacy expectations were strong enough to qualify them as owners under the Third Amendment.
That's a huge shift. It takes the amendment from being about property deeds to being about privacy in your living space.
Absolutely. It connects the Third Amendment directly to that penumbra of privacy rights the Supreme Court talked about in cases like Griswold v. Connecticut, which dealt with contraception. It shows this old amendment isn't just about soldiers anymore. It's part of the Constitution's broader shield for personal privacy in the home.
So why this matters for you listening now? This ruling means your constitutional protection against government intrusion in your home isn't tied just to having a mortgage or a formal lease.
Right. If you live somewhere lawfully and you have a reasonable expectation that it's your private space, maybe employee housing, maybe you sublet, maybe some other non-traditional setup emblem, suggests you might have Third Amendment protection too. It hinges on your expectation of privacy, your right to exclude others.
It really gives modern life to an amendment most people probably thought was irrelevant. We went from colonial outrage over redcoats to a 1979 labor dispute, giving us this vital principle about privacy.
It's a powerful reminder that even the Constitution's quiet corners can have teeth. England took owner and made it about something more fundamental than just title deeds. It made it about the right to privacy in the place you call home.
Which does leave us with a fascinating question to think about, doesn't it? England expanded the idea of owner based on privacy, but it still involved people clearly identifiable as soldiers, the National Guard. So here's the provocative thought. What happens if the government actors trying to use private property aren't traditional soldiers? Think about a major disaster or civil unrest. Could other government agents, maybe federal law enforcement, maybe even local police acting in a large-scale capacity, ever trigger the Third Amendment if they tried to, say, commandeer part of your house or business?
That's the lingering question. We know at least one court has said standard municipal police don't count as soldiers for the Third Amendment. But Inglom opened the door by focusing on privacy and function over just labels. Could a situation arise where another type of government force acts so much like a military occupation that the Third Amendment's privacy protection could apply? It's an untested boundary.
Something to mull over. It shows how even a 200-year-old line about soldiers keeps forcing us to think about the line between public power and private life.
It really does. That line guarding the private citizen is always being redrawn.
Well, that's our deep dive for today. Thanks for joining us.
Thank you.
We'll see you next time.